Welcome to Shanrae's Indie Artist Panel, where she elaborates on all of the matters pertaining to the music game of independent artists with current information so you can stay on target. Independent artists gotta work the hardest. No big machine backing, you need to know the market. And that's where Shanrae come in at, to pass on to you and you, her knowledge. Welcome to Shanrae's Indie Artist Panel. 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 Welcome. Yeah.
And welcome to Shanrae's Indie Artist Panel. And this is my July 2025 panel. I said I don't have any guests for this evening. I wanted to come on myself, and I wanted to talk to my fellow indie artists this month, this quarter, about our intellectual property, what it is, and how we are to protect our intellectual property. It doesn't matter whether we are indie artists or not. How we can protect our intellectual property. So without further ado, let me move this on because I want to get in and out for 30 minutes. Again, this is an open panel. If y'all have any questions, I want to thank everybody. Good evening, good evening, guys. My Facebook family. Good evening, my TikTok family. My Instagram family, thank you. My YouTube family, my LinkedIn family, good evening. So I want to go on and let's open this up. I'm going to open it up a little bit and then I'm going to close it back. Excuse me, I'm working different things. So I'm going to open it, then I'm going to close it right on back. So let's start with what is intellectual property. And we're going to talk about the 4 different things. And I'm also going to be introducing some different videos in here so you can get a better explanation about our intellectual property as indie artists, whether you're indie musician, whether you're indie painter, whether you are, we've had rodeo indie artists, we had different people on film, authors. So it doesn't matter what type of indie you are. Welcome. So intellectual property, let's get into it. Intellectual property refers to IP. Okay, and it refers to the creations of the mind, such as your inventions, maybe your literary and artistic works, sometimes your designs, symbols, names, images that are all used commerce or on social media. That is your intellectual property. It is protected by law, and it is primarily through copyrights, protected through copyrights, through patents, through trademarks, and through trade secrets to grant you, the creator, me, the creator, the rights over our own works and our own original creations, and encouraging innovations and creativity. Our film writers, all of this. So, and let me see. Hi, Jamal. Hey, Jamal. Hey, Chipper. It's so good to see y'all. Okay, so I have opened it up. I'm going to give you a video that will better explain this, and then we are going to move on from there. All right, so let's get to I'm trying to work so many different things. So I'm trying to get it started, guys. And y'all, please bear with me. I just really felt the need. It's been burning the last 3 months for me to get on here and to talk about our intellectual property. We've seen so many different things in the mainstream media about people fighting for their rights. Salt and Pepper, I understand, have been fighting for their rights with their music that is over 30 years old. We've seen Anita Baker fight for her intellectual properties. We have seen Angie Stone, even the late great Angie Stone, before she passed, she was fighting for her intellectual rights. And guys, we are going to talk about it this quarter. And I may end the year in October on a part 2 about talking about our intellectual rights as artists, as indie artists, and as artists as well. Okay, so let's get this popping. Let me go on and get this up here. I have it on here, but like I said, I got monitors and stuff. Let's see if I can get this on. There we go. Let's get it going. All right. Well, that's all right. I'll get it on going. I had everything in my queue, everything ready to go. All right, we're gonna get it on. Here we go.
What is intellectual property and why do I care is something that I get asked all the time. After I finish explaining what intellectual property is, a lot of people just right away they say, hey, I've got ideas, but I don't have any intellectual property. So intellectual property is more than ideas. Intellectual property is trademarks, copyrights, trade secrets, and patents. Most people have heard of patents, but just an idea by itself is not a patent, is not a trademark, is not a copyright. Your ideas might be secrets, so you need to keep them secret until you can figure out what they are. So why do you care? Because companies' values, projects' values, inventions' values are in that intellectual property. Most companies in the US and the EU have almost half of their value. So if you look at something like Coca-Cola, their market value is $100 billion. But then if you looked on their actual hard assets on their balance sheet, what they actually have paid for, owned, sitting right there on their balance sheet, that's about 40 billion. That difference is their brand, their trademarks, their goodwill, their intangibles. It's their intellectual property. So that's why you should care about intellectual property, because it is very, very valuable. So what you need to do is you need to figure out what your intellectual property is so you don't lose it. We have lots of examples of people toiling away. You might work for company X and on the side you're coming up with this great idea, this great invention, only to find out later, oh wait, I don't own that. I actually signed an employment contract with company X that said that anything that I invented, they owned. So people will lose their intellectual property if they don't understand what it is. And so you need to care because you don't want to lose something that you work for a couple of years on. The other side is you need to know what intellectual property is because you might be accidentally infringing on someone else's intellectual property. For example, you create a crowdfunding campaign, you go out and you grab a song off the internet and you've put it in the background of your video. Cool video. Potential infringement suit. And if you grab clips from movies, for those of you who watch right at the end, there is a basic warning that tells you that a copyright violation, if you're charged, is $250,000 a violation. Nobody wants to do that. So you need to make sure that you understand intellectual property, because it's not just Apple and Samsung who are arguing over this. It's in everybody's business. So make sure that you know what intellectual property is and get informed so that you can keep your company's value.
Okay, so now we know what intellectual property is. We're getting ready to break down. Let me put this back up here. We're getting ready to break down. Excuse me. I'm sorry. Let me remove this. Guys, I'm working so many different so many different things. Let's add this in now. Okay. So now we know what intellectual property is. Excuse me. Oh, come on. It don't want to. There we go. Let's put this in here. I got PowerPoints and everything, but guys, it is my mouse. I have three monitors and I'm working them all at the same time. So let's move this in right now. Let's remove that.
Property is a lot of.
I'm sorry. We're going to stop that and remove that. All right, let's add this. There we go. So now let's talk about the 4 different forms of intellectual property, aka IP. All right, so number 1, we have patents. A patent is where you grant exclusive rights for inventions, including your products and your processes. Okay, then we're going to talk about your trademarks. All right, your trademarks is something where you protect your brand name and logos used to identify goods and services. All right, so a lot of us indies, we want to brand our name. Hey, New Life, how you doing? We want to brand out your name, and or you have a logo. Okay, so that's a trademark. You need to trademark it. Then we're gonna move into trade secrets. Trade secrets are normally used for like these big brand companies, like Amazon and stuff like that. Then, of course, copyright is for us indies, where we're copyrighting. Like I'm a musician. Those that are authors, that are playwrights, that are filmmakers, copyright your inventions, your creations. Okay, so to better explain these four different IPs, or these four different intellectual properties, I'm going to bring on another video that should help you better understand it. And like I said, we're going to get in and out. But it is so important that we as indies protect our creations. It doesn't matter. And let me move to the screen like this. It does not matter whether we're mainstream artists or not. We still have, you can say I'm prejudiced, but we as indies, I say that we are so creative. We are actually a lot more creative than those that are in the mainstream, because mainstream artists and film writers and stuff like that, they have a whole big team of people where they're coming in and collabing and doing stuff like that. But us as indies, because we don't have that large capital and the budget and the big team, we have to use our brains and our creations, and we put forth our own personal love, our own personal babies. I'm going to put it that way. And so again, this month, this quarter, it is dedicated to trademarking, to copywriting, for us protecting our intellectual properties. I don't care where we are right now. We could be in the beginner stages as an indie artist, or indie, whatever you are, musician. Still, it is very important to protect your creativity. And so I'm going to go on and bring on the next video that will help you further understand the four different types of intellectual properties, aka IPs. And again, the importance of protecting it. Okay, so here we go. Let's get this video up and going. Here we go. I'm sorry. Let me add this to the stage. Okay. Y'all bear with me. Like I said, my mouse is cutting up and it don't want to act right. Here we go. Uh-oh.
Very misunderstood topic. It's not a very intellectual property, or IP, a very misunderstood topic. It's not a very exciting topic, but there are four different types of IP, and it's very important to understand the four types of IP. First, the patent. People always talk about patents. You hear people saying, oh, I have this great idea, I'm going to patent that. Oh, this is a great name for this product, I'm going to patent that. It's very misunderstood. Patents are basically the right to exclude other people from making whatever you've created. There are some crazy patents. For example, there's actually a patent for a bird diaper. That would mean that if anyone other than that person decided they were going to make a bird diaper, that person could have stopped them from making the bird diaper. But the way it works is it's an exchange with the government. You're excluding other people from making your bird diaper, but you have to disclose how that bird diaper is made in detail. It's online, it's at the USPTO. You have to disclose that, and then after your patent runs out, which could be anywhere from 14 to 17 years to 20 years, depending on when you got your patent, at that time, the rest of the world can just go right ahead and make bird diapers. So there are two types of patents. There's the utility patent, and then there's design patents. But the whole thing to understand about it is it doesn't give you the right to make whatever you've created. Because, for example, with our bird diaper, there might be something that's used in that someone else has a patent on. So you might have to go and ask them for the use of their, let's say, Velcro adhesives for the bird diaper. Now, that can get really complicated. And this patents is an area, there's just been a huge change in the law in the US, and it's an area that you must consult with a professional, and often that is a patent attorney. Understanding that you're not going to patent a name gives you a little bit more information. What are you going to do with a name, though? A name is something you can trademark, you can copyright. A trademark is something, one of the most famous trademarks would be Coca-Cola, Apple. These are brands. So what you're doing is that trademark for Coca-Cola on the bottle tells you that if I pour the contents of that bottle into my glass, I, as a consumer, am protected. I'm not going to get Pepsi. I am going to get Coca-Cola. That's the deal that is made. So the exchange is Coca-Cola pays for that trademark, they have the right to use it, and as long as they renew it, they get to keep using it. Now, Coca-Cola is a really great example of a trade secret. So a trade secret is often used instead of a patent. So if you think about the recipe for Coca-Cola, that has been around for over 100 years. If they would have patented the recipe and the process for making Coca-Cola way back when, it would have long since been an expired patent, and then everyone in the world would know how to make Coca-Cola. So what they do instead is they keep it as a trade secret. You don't necessarily have to go to an attorney to protect a trade secret because there isn't any way of filing like there is for a patent, a trademark, or a copyright. So with trade secrets, you do have to consult with a professional to make sure that however you're protecting it is proper and will meet whatever state law it applies to you. Now, with Coke, they do something really cool with it. They actually have divided up the secrets, so there's very few people who know the entire process. There's restaurants where there's secret recipes, and you'll actually have different kitchens where part of the process is done in one kitchen, part of the process is done in a different kitchen. There's many people will say, well, hey, I don't have any trade secrets, but things like customer lists, supplier relationships, these are trade secrets. Know-how about how you put together your software, trade secret. So with trade secrets, they're basically free to protect, but the very important thing about them is once the cat's out of the bag, that's it, no more trade secrets. So it's a pro and con between trying to patent something and keeping it as a trade secret. A final piece of IP is copyrights. Copyright does not mean the right to copy. So what it means is that if once I write something down, once this video is recorded, someone has copyright in this video. And then that doesn't mean that nobody can copy it. What it means is that you have to figure out what are the permissions of use. For example, there's a great site, Creative Commons, where people put things on there, photographs and videos, and people can come and use them once you read the permissions. So the copyright is with the author. It lasts for the life of the author plus a number of years that keeps increasing. So as an author, you don't really have much to worry about during your lifetime, but then it becomes really interesting after someone dies. And a really good example of that is with Walt Disney, because the things that Walt Disney has created are all copywritten, but Walt Disney has passed away many years ago. So a lot of people refer to copyright as kind of the Disney law because the years after the author's death keeps getting bigger and bigger. So those are the 4 types of IP. You have your patents, your trademarks, and your copyrights, and your trade secrets. And for those of you who are still watching, thank you. And you might want to ask yourself, why? Why do I care about this? Because actually almost half the value of most companies in the US and the EU is intangible assets, and those intangible assets are intellectual property. It's the patents, the trademarks, the copyrights, and the trade secrets. So make sure that you understand what those things are so you can make sure that you protect them.
Okay, so I know that it tends to be a bit like when we're talking about um protecting our works, our creativity. Now, this is not just for indie artists. This is for indie chefs. If you're a chef and you come up with a secret sauce, you need to protect your secret sauce. Like she said, trade secrets. If you are a I don't know if you are a vocal coach, or if you are even a teacher. And when I say a teacher, that's a teacher is a great a miracle worker. If you have found a way to connect with students, whether they're adults or children or youth, and you found a way to connect with students, patent, copyright, trademark, trade secret your creativity. You don't have to be a mainstream on the mainstream doing anything. If you're in, because I wear many hats, I'm not only an artist, I'm also a degree counselor. I'm an author. I'm a different type of, I'm also a mom, I'm a wife. If you have come up with a way in your home to make something easier, like you come up with a simpler way to clean but more effective way, patent that idea. You as a man or a woman, if you're into mechanics or something and you've come up with a way to fix a car or to clean a car, or even if you're a pet groomer, if you've come up with a way to keep, because I'm a pet mom. It is the hardest thing to get their fur up out of your car or out of your furniture if they happen to jump on your furniture when you're not home or something like that. And so if you found a way to get that stubborn hair up off of out of the floor or off of something, patent your idea. I'm sorry, I'm going to put this on here. Guys, y'all, I've got a lot going on. Patent your idea. It is imperative to patent your idea. So you don't exactly have to be an indie artist. If you come up with a brilliant, how you doing, WGTD? If you come up with an idea, protect it, because you don't know, like she just said in the video. Listen, your ideas that, and I am a Christian, I'm not trying to push that down anybody's throat, but any ideas that God has given you, or some people say the creator, if your creator have given you a light bulb moment, protect it. Protect it. This has been on my heart for the last few months, how important it is to protect our creativity. So we just talked about copyright. What is a intellectual property and how to protect it? The four different things, the four different forms of intellectual property, aka IP, and how to protect it. The four different ways to protect your intellectual property. Now let's talk about, which is another form of intellectual property. Let's talk about our digital rights management. Because a lot of things now are done this and digital that. So that there's a lot of people that are creating this and digital things, and how you can protect that as well. So let's go on and let's look at this next. This is our final video for the evening. But I want to talk about how to protect our creativity. So here we go.
Central to the ability to protect copyright claims online is technology that falls under this broad category of digital rights management, or you've probably heard it referred to as DRM. DRM is something that, I'm not sure what the future of DRM is. But the goal of DRM is to use a combination of software and hardware techniques to limit what you can do with some sort of digital content that you've purchased. So let's say you buy a song online. So if that song is not protected by DRM, you can do things like copy it, send copies to everyone you know, remix it, whatever. So, and this is stuff that, again, without digital rights management, play it on any machine, Obviously, if you can make copies of it, everybody can experience this, and you can share this online. You could distribute it via some sort of music sharing website, and anybody could use it. And so the goal of DRM is to shut down some of these things. So, for example, music that has some sort of successful digital rights management attached to it might prevent you from copying it. It might prevent you from sending copies to everyone you know. Maybe you can only send a few copies to people, maybe. If you can't manipulate the music in its direct form, it's hard to make remixes. And it might only, it might only let you play it on a few machines, maybe a couple of machines that you own, at which point it would require that you buy it again or something like this. There were a couple problems with digital rights management. So from a conceptual perspective, digital rights management, early versions of it, and I would argue even today's versions, never matched the expectations that people had for stuff that they purchase. So imagine we're pre-MP3 and I buy a CD. What can I do with that CD? I can take that CD and without doing anything illegal, I can give it to Greg and he can take it home for the weekend and he can check out the music. That is actually typically covered under fair use. I can, put that CD in the CD player in my car, and I can put it in the CD player in my friend's car. And so there's some sense in which our ideas of ownership over content were never reflected by these DRM schemes, because despite the fact that they, were technology-based, they never quite matched up with our intuition about what we should be able to do with things that we own. So that was the first problem. The second problem with DRM was that some of these schemes were just comically easy to defeat. And here's the thing, you don't need everybody to defeat their DRM schemes. You only need one person. So if some hacker somewhere can break the DRM on a particular type of Apple Music product, then they can start to get access to the full content, and then they can start distributing that, and pretty soon everybody has it. So, DRM is only as strong as its weakest link. And there are some very determined people out there who were also, got a fair amount of publicity and, street cred on the internet, in the internet hacker corners, for being able to defeat some of these DRM schemes. Some of them were also just really badly designed. So anyway, the idea here is that, can we use software and hardware to prevent you from doing things with content? Yeah, maybe. Some of these schemes also had the side effect of really irritating users. They prevented users from doing things that seemed natural to them. They, in certain cases were found to be spying on users. There was one case of a very, very badly designed Sony digital rights management scheme that actually installed a rootkit on users' devices to try to track what they were doing with that particular piece of content. So that was a terrible idea. So anyway, the future of this sort of thing is to me sort of fairly uncertain. Unfortunately, again, DRM has a pretty poor track record of being breakable. And doesn't stop people who are even mildly determined from getting their hands on legitimate copies of the content. And I think to work better, DRM schemes have to match and align better with the type of expectations we have over things that we own. So if I buy a particular music track, I should be able to share it with some friends, not everybody. And I should be able to play it on all my devices, and I should be able to remix it if I want to do that if I'm a DJ or whatever. So, moving forward, will we see this type of thing out in the world? I don't know. It'll be interesting to see what the future of digital rights management is in terms of trying to protect the rights of copyright owners.
Okay. All right. So, to review what we just saw, and I know it's a whole lot, and we're almost at the end of everything. What this means about digital right management. For instance, these are some examples of digital content. Your streaming services. Those of us that are artists, I'm a singer, so my music is on YouTube, it's on Spotify, it's on Apple, it's on iTunes, it's on almost Amazon. It's on every streaming service. Your streaming services, that's digital. Ebooks, that's digital. Software distribution, if you're into IT, that stuff is digital. There are a lot of people, these young people, they're creating and they're making creating games and apps and stuff like that. All of this stuff is digital. Online gaming services, again. There are people that are creating digital digital things that will help, whether it'll help you help whatever. All of these things need protection, and that's what the gentleman that I just had on, that's what he was describing about digital protecting your rights like that. Okay, let me add this in. Excuse me, let me add this in. So this again, these are the examples of your digital type of things, the streaming services, the ebooks, and different things like that. So, well, without further ado, this is going to be it for our quarter, our third quarter for our indie artists panel. And y'all know this is the educational thing that I do every 3 months for us indies. But again, and let me make this a little smaller. There we go. Again, this has been on my heart to talk about our intellectual property and how to protect it. Whether you feel like you're doing something with it, if you come up with an idea, whether you're an indie chef, because we know that there are famous chefs out there. If you're not a mainstream chef, but you are a chef, you come up with something, a wonderful plate. If you come up with food, anything, sauces, protect your ideas. If you are a film writer, if you are a playwright, protect your ideas. Okay? It doesn't matter what type of indie you are. Like I said, I had a couple of years on, I had an indie rodeo. He rode bulls. Well, there's different things that he has come up with to help him become the best rodeo rider. He needs to protect his ideas. So this is why I wanted to talk about intellectual properties and how to protect your intellectual properties with this quarter. I think I'm actually going to come back with a part 2 in October, and we're going to further get a little bit more in depth on how to protect our intellectual property, aka our IP, or our ideas and our different things that we create. Do not say to yourself, oh, that's not, oh, nobody will never buy this, or no one will ever be interested in. Don't say that. Don't discount the creativity that you have. Whether you are indie hairstylist, whatever, do not discount the creativity and the ideas that you come up with, and protect it. You don't know where it's going to take you in your life. And remember, our ideas, like one of the first and second video that I showed tonight, it goes far past even our lifetime. Protect your intellectual property, guys. All right. And this has been Shanrae's July 2025 Indie Artist Panel. I'll see you October, possibly with a part 2. Y'all have a good night. Bye-bye. Lord, this thing don't want to come on. I'm trying to give y'all my little outro. It don't want to come on. Ooh, Lord, I had everything set up. That's okay. I'll just play it manually. All righty then. Have a good night, guys. Oh, I don't want to play. You don't want to play. Good night. Good night, everybody.
Welcome to Shanrae's Indie Artist Panel, where she elaborates on all of the matters pertaining to the music game of independent artists with current information so you can stay on target. Independent artists gotta work the hardest. No big machine backing, you need to know the market. And that's where Shanrae come in at, to pass on to you and you, her knowledge. Welcome, 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 welcome to Shanrae's Indie Artist Panel. Welcome, 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 welcome to Shanrae's Indie Artist Panel. Welcome.